Today, the U.S. Supreme Court decided that it would not review a decision that had been made by the Federal Appeals Court, in which that court said that the ACLU should receive a preliminary injunction enjoining this law from being enforced against ACLU staff, while the trial court held a final trial to determine whether or not the law was unconstitutional. However, in that decision, the Federal Court of Appeals was quite emphatic that it was likely that this law was unconstitutional when it was applied to people audio recording police officers in public while those police officers were performing their public duties. Right now, under the law in Illinois, you could photograph a police officer going about his duties in public. You could video record them. You could also listen to them and take notes of their conversation. The sole thing you cannot do is audio record them, and that, of course, is what we want to do. As a condition of going forward in this case, the state's attorney of Cook County made a representation to the trial court that while this case was going on, it would prosecute no one for audio recording police officers in public while those officers are performing their public duties. The ACLU has already filed a motion for summary judgment in which we request that the trial court make the injunction permanent. That is, that the court first rule as a matter of law that the Illinois eavesdropping statute is unconstitutional when it's applied to this particular conduct. And I want to stress that this lawsuit is about openly recording police officers while they're performing their public duties in public and when they're speaking at levels that are audible to a passerby. So that is the precise issue that is framed by the lawsuit, and we request that the court decide that legal question, and if it decides it in ACLU's favor, that it then enters an injunction which actually prevents the Cook County State's Attorney from enforcing the law against the ACLU staff when they are engaged in our police monitoring project, in which we use both video and audio capabilities to record the conduct of police officers. Once the court rules, and hopefully will rule in favor of the ACLU on the law itself and actually determine that it is unconstitutional, then that would create a precedent that would in effect prevent the state's attorney from prosecuting other people. And I want to explain that it is a two-stage proceeding that we have been engaged in. Because the ACLU requested first a preliminary injunction just to have protection in place while the case was ongoing, the courts are only required to determine whether it is likely that a law is unconstitutional before it reaches a final decision and enters a final and permanent injunction. So the issue that went up on appeal to the Federal Appeals Court was whether we should have a preliminary injunction or not. And so they found that we should, but they didn't strike down the law completely in this application. Instead, it said that it's likely that it's unconstitutional, and so we must go back down to the trial court for a final decision. We're going to file a motion with the court, the trial court here in Chicago, right away. We expect in the next few days to request that the court start the process going to reach a final decision on the merits and to enter a final injunction.